California real estate broker license. Let's get started. A California real estate broker is acting as a dual agent in a transaction with the full knowledge and consent of both the buyer and seller. In this situation, which fiduciary duty is the broker not required to provide equally to both parties? Is it A, obedience? Or B, confidentiality regarding price motivations? Could it be C, disclosure of all material facts? Or lastly D, reasonable care and diligence? The correct answer is B. Here is why. Confidentiality regarding price motivations, option B, is correct. In dual agency, the broker cannot disclose the buyer's maximum price to the seller nor the seller's minimum price to the buyer. This duty of confidentiality is suspended between parties. Option A is incorrect. Obedience to lawful instructions is required. Option C is incorrect. Material facts must be disclosed to both. Option D is incorrect. Reasonable care is owed to both. Next question. If a salesperson in California misinforms a buyer as to deed restrictions, what is the potential liability? Is it A, no liability if restrictions are a matter of record? Or B, salesperson and broker may both be liable for damages? Could it be C, only the salesperson is liable? Or lastly D, only the principal is liable? The correct answer is B. Here is why. Salesperson and broker may both be liable for damages, option B, is correct because the broker is responsible for acts of their salespersons within the scope of employment. Option A is incorrect. Recorded restrictions do not excuse affirmative misrepresentation. Option C is incorrect. Broker is vicariously liable. Option D is incorrect. Both agent and broker may be liable. Next question. A California buyer purchases a condominium unit and receives the covenants, conditions, and restrictions CC and RS, along with the HOA's governing documents during escrow. If the buyer later discovers a restriction prohibiting pets over 20 pounds that was not verbally disclosed by the agent, but is clearly stated in the recorded CC and RS, what is the buyer's most likely legal recourse against the selling agent? Is it A, the agent is liable for failing to verbally disclose the restriction? Or B, no liability, as the restriction is a matter of public record? Could it be C, the agent must compensate for any relocation costs? Or lastly D, the buyer can rescind the sale within 3 business days? The correct answer is B. Here is why. No liability, as the restriction is a matter of public record, option B, is correct. Agents have a duty to disclose known material facts, but CC and RS are publicly recorded documents provided during escrow. The buyer is presumed to have constructive notice. Option A is incorrect. No duty exists to verbally recite every recorded restriction. Option C is incorrect. No statutory relocation compensation applies. Option D is incorrect. No 3-day rescission right exists for condominium purchases. Next question. Under California's agency disclosure law, Civil Code Sections 2079 etc., when must a real estate agent provide and obtain a signed agency disclosure form, AD, from both the buyer and seller in a residential transaction? Is it A, only at the time of listing the property? Or B, as soon as practicable before the buyer makes an offer? Could it be C, only if the transaction closes escrow? Or lastly D, at the close of escrow when title transfers? The correct answer is B. Here is why. As soon as practicable before the buyer makes an offer, option B, is correct. The agency disclosure form must be provided and signed before or at the time the buyer makes an offer. Option A is incorrect. Listing agents provide disclosure to sellers at listing, but buyer disclosure occurs at offer. Option C is incorrect. Disclosure is required regardless of closing. Option D is incorrect. Disclosure at closing would be too late. Next question. Under a trust deed in California, Who is the trustor? Is it A, signs the note as maker? Or B, holds the title to the property in trust? Could it be C, acknowledges the note for recording? Or lastly, D, lends the money? The correct answer is A. Here is why. Signs the note as maker, option A, is correct. The trustor is the borrower who executes the promissory note and trust deed. Option B is incorrect. The trustee holds title. Option C is incorrect. Acknowledgement is performed by a notary. Option D is incorrect. The beneficiary lends the money. Next question. Federal law in California protects purchasers of subdivision properties offered for sale in interstate commerce by providing a right of rescission within how many days? Is it A, 3 days? Or B, 5 days? Could it be C, 7 days? Or lastly, D, 10 days? The correct answer is C. Here is why. 7 days, option C, is correct under the Interstate Land Sales Full Disclosure Act. Purchasers have 7 days to revoke the contract. Option A is incorrect. 3-day rescission applies to home equity loans and some refinances. Option B is incorrect. 5-day is not a standard federal rescission period. Option D is incorrect. 10-day rescission applies to certain military lending scenarios. That's it for today. How many did you score? Let me know in the comments. Please like and subscribe, and tell me what topic I should cover next. Bye.